Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. It may not seem like it, but appellate courts have distinct personalities. The way that a Second Circuit Court of Appeals court might handle a prisoner rights case is different from the way an Eighth Circuit court would, or a Ninth Circuit court. The courts are made up of different judges, and each one has a different take on its own judicial philosophy. The Fourth Circuit seems to have the personality of being very protective of the citizenry at large when there is a Fourth Amendment claim. This is the case of Anthony Miller versus two police officers, Officer Brown and Officer McComas. And there is court-appointed or court-assigned amicus counsel in this case, sort of standing up for the rights of Fourth Amendment claimants everywhere. On the early morning of June 7, 2019, two police officers spotted, detained, and seized Mr. Anthony Miller as he sat in his vehicle in his driveway. At the time, the officers were investigating a nearby stabbing, but they did not have a witness to the crime or a description of the potential suspect. After his short detention and release, Miller filed a single claim, a pro se complaint, against Officers Brown and McComas under 42 U.S.C. Section 1983, and he asserted his Fourth Amendment rights were violated. The district court disagreed with Miller and granted summary judgment to the officers and found that their actions were justified under the totality of the circumstances. The Fourth Circuit says, "We disagree and conclude that the officers lacked sufficient, reasonable, particularized suspicion as to Miller and should not have seized him or searched his vehicle. Accordingly, we vacate the district court's grant of summary judgment and remand for this matter for further proceedings." Now the court gets into the facts. So there's a call at 4:20 a.m. It's an anonymous call about a guy stabbed in the chest who's bleeding and banging on the doors of a local gas station. So an officer goes to the gas station to investigate. He finds a guy with a deep slash on his arm and a makeshift tourniquet, and he tries to talk to him. But even though he tried to talk to him, the man didn't respond and continued to scream at the attendant. Here's what the officer noted about him. He smelled like alcohol, and he wouldn't provide any information or assist the cops in trying to find out who'd hurt him. Consequently, the officer couldn't determine how, where, when, or why the man had sustained his injury. Likewise, the cops had no description of the stabbing suspect. A medic unit arrived and began tending to him. They got in the ambulance, tried to question him again, still couldn't find anything out from him. And so they had a helicopter there. Initially, they thought they might have to life flight him, but as it is, they're like, well, as long as we got the helicopter here, let's turn on the forward-looking infrared and see if we can find a hot vehicle nearby, and maybe that's where our stabber is. So that's what they do, and the helicopter finds a hot car about 0.2 miles away from the gas station. And so as a result, the pilot radios and says the car has its tail lights on and its headlights off, and she couldn't tell if there was somebody in the driver's seat or not. So Officers Brown and McComas drove to the residence, and before they arrived, they deactivated their emergency lights. Brown pulled into the driveway and used his cruiser's headlights to illuminate Miller's vehicle. Miller, who was seated in the driver's seat of the vehicle with his driver's door open when Brown and McComas arrived, responded by pulling the door shut. Miller later asserted that when Brown and McComas pulled up, he was in the front seat of his car searching for his headphones. Miller said that because the police did not immediately identify themselves, he believed them to be one of several people who either lived at or frequented the residence. And as such, he said, I merely shut the door to allow the vehicle to pass through and by and through to the gate so that they could park. But Brown and McComas interpreted Miller's actions through what the court calls the lens of suspicion. And they decided that he was acting suspiciously, and as a result, they drew their weapons and they ordered him to come out of the car with his hands up. They ordered him to walk backwards toward the sound of their voice with his hands in the air, then had him kneel down, and they handcuffed him and put him in the back of the cruiser. So Brown and McComas searched the car and they didn't find any weapons or evidence related to the stabbing. And after frisking him, they didn't find anything that provided any clues to what was going on. They asked him for ID. He initially refused, but his parents came out on the driveway and showed the officers Milla's ID, and they confirmed that Milla lived there at the residence with him, and the interaction with Milla took about 8 minutes and was recorded on the cruiser's dash cam. Before we go a lot further, one of the things I think that is important to note is that when it's dark outside and you're parked in a car and a car comes up either behind or in front of you and they have their lights on, particularly their high beams, which is traditionally what cops do, it is very difficult to make out any red lights on the top or know that that's a police vehicle. You just think somebody is coming up behind you. And in today's day and age, I think it would be kind of stupid to leave your door open when somebody came up behind you with their lights blazing, in large part because you wouldn't know whether or not they were a carjacker. Milla filed a pro se complaint, and that was his first mistake. I've said it time and time again, if you are going to prosecute a claim against anyone, you need to do it with an attorney if at all possible. And if you don't do it with an attorney, you need to sit down and read the rule book and figure out how the process works, so you don't make procedural errors that wind up costing you a potentially valid claim. So Milla's complaint asserted that the officers violated his Fourth Amendment rights by accosting him while he was seated in his own car in his own driveway, and by detaining and frisking him without reasonable suspicion and searching his car without probable cause. Despite filing his complaint, he struggled to prosecute his case because, again, pro se litigants don't understand how things work in federal court, and it isn't like, Judge Judy. It isn't like small claims court. You actually have to follow the rules and follow the procedures, and if you don't, you lose. So during the course of the case, Brown and McComas moved for summary judgment, arguing that they held an objectively reasonable and articulable suspicion to detain Milla based on their investigation of the nearby stabbing, the early morning hour, the fact that Milla's car was stopped outside the gate of a residence that they did not know was his, the fact that Milla's car had recently been driven, and that person, Milla, was crouched in the driver's seat for a sustained period of time, and their observation that Milla closed the door when they arrived. The officers further claimed that the frisk and protective sweep of the Milla vehicle were valid, given the limited information available to them at the time. And this is an assertion that will come back to bite them later on. They also sought qualified immunity, claiming that it's not firmly established that an officer's brief detention and protective search is necessarily a violation of the Fourth Amendment rights. On the first page of their motion, defendants included a footnote warning Milla that his case could be dismissed if he failed to respond and provide affidavits contradicting defendant's summary judgment motion within 21 days. However, the record does not show the court ever issued a similar warning, and they have a rule in the Fourth Circuit that the court must issue that kind of warning before it terminates the case on summary judgment. Milla responded to the motion, but he didn't provide affidavits. And as I mentioned recently, motions are not self-proving. Responses to motions are not self-proving. If you assert a fact, you have to cover it with sworn testimony, either by deposition or affidavit or document, something like that. In his response, he argued the police lacked reasonable suspicion to detain him. Milla claimed that when Brown and McComas approached him, he was seated normally in his car and that his behavior was not evasive. He further pointed out that the officers never had a description of the suspect or suspect vehicle, yet they ignored other hot vehicles in the area and chose to focus on his. Additionally, he noted the victim refused to speak to the police, and the police didn't know whether a crime had occurred or didn't, and they didn't know which direction from the scene to start looking. In other words, they didn't have a direction of travel. In spite of that well-argued position, the district court granted summary judgment to the defendants. It found that based on the totality of the circumstances, they had a reasonable suspicion and that it was reasonable in light of the totality of the circumstances. And the court also held the officers were entitled to qualified immunity because they didn't violate the constitutional rights. So the Fourth Circuit says, look, we look at this de novo, viewing the facts and inferences reasonably drawn therefrom in the light most favorable to the non-moving party. And of course, the non-moving party here is Milla. And they go through the fact that the Fourth Amendment protects the right of the people to be secure in their persons against unreasonable searches and seizures. And they talk about Terry stops, which are predicated on a reasonable, articulable suspicion that criminal activity may be afoot. Now, reasonable means objectively reasonable. It can't just be reasonable to the officer. It has to be articulable. He has to be able to say, look, I felt this was suspicious because, and as a result, if he can't do that, then he doesn't have a reasonable basis to stop someone. Courts measure reasonable suspicion based on the totality of the circumstances, and reasonable suspicion requires more than a mere hunch, but is less demanding than probable cause and may well fall considerably short of satisfying a preponderance of the evidence. Reasonable suspicion to initiate a Terry stop requires a particularized and objective basis for suspecting the particular person stopped was engaged essentially in criminal activity. And the officer must be able to point to specific and articulable facts which, taken together with rational inferences from those facts, reasonably warrant the intrusion. Seemingly innocent factors, when viewed together, can amount to reasonable suspicion, but the circuit decries government attempts to spin largely mundane acts into a web of deception. In other words, you can't take 4 or 5 facts that could be explained in the absence of criminality and weave them into criminality just because, in your twisted mind, that's what they mean. The court goes on to say, even if an investigative stop is justified by reasonable suspicion, a subsequent frisk or search is not permitted. Any frisk must be supported by a reasonable suspicion that the suspect is armed and dangerous. Now, Miller maintains that neither officer can satisfy their burden to show that they had reasonable suspicion. And of course, they disagree. They say, look, it was late hour at 4:30 in the morning, close location of the car relative to the victim and the evidence of the car's recent operation, Miller's presence in his car, the absence of other persons in stopped hot vehicles in the area, temporal proximity between the time of the apparent stabbing and the location of Miller's car, and Miller closing his door when approached by defendant officers. Despite the length of this list, we cannot agree that these factors, when viewed separately or together, were sufficient to form reasonable suspicion. Brown and McComas lacked an objective basis to suspect Miller specifically engaged in any crime, and thus lacked the requisite particularized basis for the stop. None of the circumstances identified by the officers support their conduct. First, this court has explained that nearby exigent circumstances, like this recent stabbing, don't justify a warrantless seizure unless the seizure is narrowly targeted based on specific information of a known crime and a controlled geographic area. So, if you had a stabbing and the person who did the stabbing was a white guy with red hair wearing a white t-shirt and blue jeans, and the person that you stop fits those requirements and you find him close to the scene, well, then you may very well have reasonable articulable suspicion. But if you stop an African American man who's dressed in a red shirt and had on white pants and was not in any way related to this, was found in a different direction of travel from where the actual crime took place, well, then you're not going to meet that requirement. And so they looked at this very closely, and you have to give them credit for doing that because not all courts are going to look at this level of specificity when they're reviewing one of these claims. They drop a footnote here and they say they don't dispute the fact that Miller was seized and that the officers drew their weapons and began issuing verbal commands for him to exit the vehicle with his hands raised, walk backwards toward their voices, and kneel on the ground. And then after he complied, they threw him in handcuffs and tossed him in the back seat of the car. The court then goes on to discuss the Curry case, and they said in Curry, officers approached Curry in an open field, one of several possible escape routes after a shooting, in an area that they only suspected to be near the scene of an unknown crime. Like here, the officers lacked a description of the assailant, did not know whether the suspect was in the vicinity or in which direction he fled. We found this insufficient for reasonable suspicion. Allowing officers to bypass the individualized suspicion requirement based on the limited information that they had, the sound of gunfire and the general location where it may have originated, would completely undermine a fundamental Fourth Amendment protection and create a dangerous precedent. And Curry is a good decision in that regard. If you don't have a particularized suspicion that an individual did something wrong, then you shouldn't just be stopping people right and left thinking, well, maybe this guy did it or maybe that guy did it. Because again, that is a violation of their right to be left alone. And we all have a right to be left alone unless we are truly guilty of committing a crime, and then you have to be stopped for the crime you committed, not for the crime somebody else committed. The court goes on to say Brown and McComas cannot use the mere fact that a stabbing might have occurred somewhere nearby to justify the seizure. Curry held that proximity to gunshots does not permit a suspicionless seizure. The same is true of proximity to a suspected stabbing. The nature of the anonymous tip further weakens the officer's argument. In other words, they didn't know who called this in. They didn't know if it was true. The officer went there and found the guy bleeding, but there is at this point no definitive statement that he's been stabbed by someone. He could have done it himself. The tip alone is not enough to provide reasonable suspicion. It's also true that the context of the stop, the crime rate in the area, and nervous or evasive behavior can create reasonable suspicion. Nevertheless, we regularly find that claims based on the late hour or nature of the neighborhood, without more, do little to support a claim of particularized suspicion. Here, the time that the officer sees Milla, 4:30 in the morning, may still be nighttime for most, but for others, it might be the start of a morning routine. So the time of day adds little to the analysis. Mere proximity to the suspected crime falls far short of supplying the officers with reasonable suspicion. Suspicion, as such, the proximity between Milla's car and the gas station doesn't offer much justification for the stop when police fail to demonstrate similar urgency regarding other potential suspects in the area and when nothing suggested that a vehicle had even been involved in the accident. Several things unrelated to criminal behavior explain Milla's actions prior to his seizure. Though other factors contribute to the totality of the circumstances analysis, individual behavior is the only substantial basis for particularized suspicion. On its face, none of Milla's conduct was criminal. His slumped posture in the seat and shutting the door when the police arrived were akin to furtive flight or evasive movement, according to the cops. But Milla's actions were not evasive. At most, they were a decision to ignore the police and go about his business. And the refusal to engage with police is not by itself a valid basis for reasonable suspicion, stating that while headlong, unprovoked flight is inherently suspicious, refusal to cooperate or acknowledge the police is not. An individual has a right to ignore police and go about his business when an officer approaches without reasonable suspicion or probable cause. Refusal to cooperate without more does not furnish the minimal level of objective justification needed for a detention or seizure. In fact, the appellees here cannot clearly argue that Milla even recognized them as police officers before he shut the door. And they quote a case that says an arguably evasive action doesn't constitute a finding of reasonable suspicion where the officer is not recognizable as law enforcement. Now, the appellees cited a bunch of cases, and the court says, look, these cases don't convince us that the stop and seizure were justified. And then they go through and pick apart these cases cited by the officers and say, well, that's not applicable here, or it's an opposite. And they go down to a case called U.S. versus Foster. In Foster, we determined that a detective's prior knowledge of the defendant's criminal record, the defendant's sudden appearance from a crouched position in the passenger seat of the vehicle, immediately after the individual in the driver's seat had apparently said something to him after seeing the detective walk towards them, and the defendant's subsequent frenzied arm movements, whether viewed separately or together, did not constitute reasonable suspicion for an investigative stop. In fact, the officers here had much less basis for a reasonable suspicion than they had in Foster, because they knew nothing about the criminal or biological history of Milla, and they approached him in a vehicle that wasn't readily recognizable as a police cruiser. Given that we declined to find reasonable suspicion in Foster, certainly they can't prevail on their motion for summary judgment under these facts. They say that Brown and McComas succumbed to the impulse to spin largely mundane acts into a web of deception. Milla, minding his own business on his parents' property, fit no description, posed no threat, and evaded nothing. And once approached by officers, he betrayed none of the markers of furtiveness or excessive nervousness that themselves pique suspicion. So they fined for the Milla on the issue of a violation of rights, and then they address qualified immunity, and they basically say the district court's award of qualified immunity relied on its determination that the officers had a reasonable and articulable suspicion to detain Milla as a stabbing suspect. The case law required that the police officer have a reasonable suspicion supported by articulable facts that a criminal activity may be afoot to justify an investigative detention. Because we vacate the district court's award of summary judgment, we also vacate the award of qualified immunity. Now, there's more in the case. They actually decide that the rule violation doesn't bother them because it wasn't raised before. One of the things that comes up frequently in an appellate argument is, particularly with pro se litigants, is they become aware of an argument they should have made at the district court, so they attempt to make it at the appellate court, and the appellate court said, no, you've waived that argument because you didn't make it in time. And that's sort of what they've done here. They've come in and said, no, we're not gonna look at this as a separate issue because you didn't raise it in the court below. And if you don't give the court below a chance to correct its error, then we're not going to correct it for you. This is a good case. It's very protective of the individual's right to be free from unreasonable searches and seizures. And in the Fourth Circuit, it will carry a great deal of weight unless and until it's ever overruled by the United States Supreme Court. And I would point out that it may be very persuasive in some of the contiguous districts like the 5th and the 11th Circuits that are also in the same sort of general geographic area. So that's what I have for you today. If you have any comments, drop them in the comments down below. Like, share, subscribe, all that stuff we ask you to do. And, of course, if you have the opportunity today, take a moment or two, do something nice for someone, make their day better, make the world a better place, and then come on back down here tomorrow, meet me at the beach, and we'll talk about another interesting case. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.